least, I welcome all the students, especially law students from various respective law colleges across the state. Now, at a glance, I would like to throw a flash as as to why today's topic, that is IPR, copyright, and plagiarism diploma in academic, is chosen by our college, and it's important. As we all know, friends,
लाईव्ह
the
स्ट्रीम चालू आहे. माझं आलेलं
participant is
Tohit, please unmute yourself.
yes, sir. I'm audible, sir.
Yes, you're audible now.
Yes. As we all know, the primary function of intellectual property right is to protect, stimulate, and development and distribution of new product and services based on creation and exploitation in the invention, trademark, design, copyright, content, and other intangible assets. And it also provides certain exclusive rights to inventors or creators of the property. Hence, the state topic is utmost vital for us to unveil it in depth. Moreover, plagiarism and its dilemma in academics is also a relatable vital aspect for a law student, as a plagiarism is a key step to maintaining the intellectual integrity of research, and it helps to ensure originality and maintain the credibility of researchers. Plagiarism often create a dilemma in academics life of each of us, and to resolve the same, the today's webinar is utmost important, and hence motive of our college to make us students notify with reference to today's topic. Thank you. Handing over to Mr. Avinash Salunke, sir.
Thank you so much, Tohit, for your introduction. So today we are going to organize one-day state-level webinar on IPR, copyright and plagiarism dilemma in academics. And today with us, Mr. Prahlad Jadhav, sir. As Tohit said, now he's working as an associate director at Khetan and Co Corporate Law Firm. He's working there since 2006. I request all the participants, please mute yourself. So about his biodata and his academic experience, he worked some different institute like University of Mumbai, Thakur Polytechnic, and Usha Praveen Gandhi College of Management. About his corporate experience, he's worked at Ocean Diving Center and Tushar Desai Associate. About his total experience, he has more than 20 years of experience in universities, academic colleges, and corporate firms. He's delivered his thoughts in different areas in different sessions. More than 225 sessions were held in UGC HRDC Center, academic colleges, and corporate for teaching faculties, students, and ELIS working professionals. About his academic profile, he is qualified a UGC NET exam in the year 2017. He has completed his master in library and information science from Mumbai University, and he got the second rank in his batch. He also completed his PGDLIM, it means postgraduate diploma in library and information management course from Tata Institute of Social Science, that is TISS, and certification in IPR. He is member from different committees and different committees like internal quality assurance sales committee member, in the category of external industry, expert at KG Law College affiliated to SNDT University Mumbai. Then member of Knowledge Resource Center of SNDT Women's University Mumbai. Then member of BOS Board of Studies at KG Joshi Bedekar College for the Library and Information Science stream. Then joint secretary at the Bombay Science Library Association at Bosla for the period of 2023 to 2026. Then the guest faculty, he's acting as a guest faculty at YCMU, that Yeshwantrao Chavan Maharashtra Mukti University for the Library Information Science stream. Then external examiner at the YCMU Thane branch at Joshi Bedekar College, Thane. He has presented more than 25 research papers at national and international seminar and conferences, and has won the best paper award twice for his research. About his resource person in different UGC HRDC center like Ajmer, University, Gujarat Central University, Mumbai University, JNT University, Telangana, and Babasaheb Ambedkar Marathwada University, Aurangabad. He is invited resource person at Maharashtra Government Education Department, West Zone, Mumbai for social library professional. Then he talked on some important core subjects like artificial intelligence impact on teaching and library, then intellectual property, then copyright and plagiarism, cyber laws, data information and knowledge management and personal knowledge management, search strategies for information retrieval, then Google and innovative tools for teachers and educators. He's received some awards and recognition for his social work as well as contribution in the field of library and information science. On April 17, 2023, the Business World People and Insight announced the Person with Disabilities Icon Award for the year 2023. Social Impact and Excellence Corporate Networking Award for the year 2020. The Council for Sustainable Peace and Development initiated the award that is licensed by the Ministry of Corporate Affairs and Government of India. Then a valuable person in LIS domain by Vertex Research and Technology, Tamil Nadu, in the year August 13, 2021. Then Altage Learning Solution Private Limited recognized him as one of the India's 15 eminent librarians. That is the most of the recognition and award received by our today's resource person. Then Levon Tech Private Limited presents the 2020 Dynamic Librarian, that is Legal Domain Award. Then Khetan and Company Professional Development and Branding Award for the year 2019 and 20. Then Gratitude Award Differently Working Realized Professionals in Maharashtra by Softtech Solution and Services Pune. In the year 2016, Sri Sukhdev Singh Award, that is Gandhi Peace Foundation, New Delhi. Then on World Disability Day, AV's Sanstha's Ambernath bestowed the Lifetime Achievement Award in the year 2016. Then Special Work Award 2017 in Education and Library for Kaikadi Samaj Yuva Sangatna Pune. Then Certificate of Recognition from Kohinoor Business and Management Schools with BKC Knowledge Network. This is the some awards and recognition received by our today's resource person. Then other awards, that is Ambernath Vaibhav Award 2022. Then LIS Excellence Award in the year 2021-22. Then COVID Yoddha Award in the year 2021. And Special Award for Social Work from Vishwabhan Pratishthan, Mumbai. So this is the resume about our today's resource person, the very energetic, very dynamic and very versatile personality with us. So without taking too much time, I would like to request our today's resource person, Mr. Prahlad Jadhav sir, Associate Director, Khetan & Co, Mumbai, to kindly deliver your thought. Thank you so much, sir.
Thank you so much, my dear friend, Salunke sir. एवढा मोठा इंट्रोडक्शन तर मला वाटत नाही की कुणी दिला असेल तेवढा मोठा तुम्ही इंट्रोडक्शन दिलेला आहे माझ्याबद्दल. फर्स्ट ऑफ ऑल व्हेरी हार्टफेल थँक्स टू यू. सेकंड थिंग, there may be a confusion in the mind of the participants how a librarian can be a resource person for the topic of IPR, copyright and plagiarism. Just for their kind information, I'm working with a law firm from last 20 years. आपण कोणाबरोबर एवढे वर्ष जर जुडलो असेल तर ती आपली सखी होते, बरोबर आहे ना. जशी आपली वाईफ असते, आपण ज्याच्यावर संसार करतो. तसंच एक जिथं आपल्याला from where we get the bread and butter. So that is the main reason from where I started liking the subject of IPR and the correlated subjects. And second thing, the topic is very interesting. I must give credit to the college for selecting such an innovative topic, because in this we had covered all the important aspects of the IPR. Not we had not even leave even plagiarism. Even we want to cover the self plagiarism issue also. And before starting, I must thanks to the organizer committee for giving me this golden opportunity, and all the participants, which is in the range of 68 plus, if I'm not wrong. I would like, if you have any questions at any moment, please disturb me. Yes, because the subject is very important. If you disturb me at that time, definitely I can answer you very briefly and very clearly. So if you have any questions at any time in the session, mid of the sessions, you can ask me. Please, sir, stop and explain again these things. I'm ready to do that. So to avoid any disturbance in the flow of the lecture, I will just off my video camera and I will go on the audio only. So please allow me for that. And the second thing, I'll also request you, please allow me to share my screen. So I'll have my presentation in front of you.
Yes, sir. You are the host now. You may please share your screen.
Yes. So can anyone from your side confirm it is visible?
Yes, sir. It is visible, sir.
Okay. Wait a moment. I'll just go to the slideshow. Okay. Now it is confirmed.
Yes, sir.
Can we go ahead? Okay.
Yes, sir.
Thank you so much. Thank you so much. So first of all, thanks to the organizer for this wonderful opportunity. And this is the topic which I really love. I know there are a lot of technicalities out there. There are a lot of deep concepts out there, but I really love this topic: IPR, copyright, and plagiarism. One of my professor friend, she's working in the Pune college. She's not from the law. She's not from the library science. She had asked me, Prahlad, can you clarify me what is the exactly you're doing in this topic where you had mentioned IPR plus copyright and plagiarism? My understanding is that copyright is a part of the IPR. Yes, madam, it is truly right. Copyright is a part of the IPR. I reverted to that message. I replied her, ki ma'am, intellectual property right is a part of the copyright. I agree with you. But if you go, IP is divided into two parts. One is industrial properties and the another one is copyright. So IPR had two branches. One is industrial properties and the second one is copyright. So copyright is the second part of the IPR. That's why we want to cover. And the second reason why we had given copyright and plagiarism, because in many of the students, academic community, this copyright and plagiarism, there are miscommunications. They think they are both the same, but no, it is totally different. So we'll go slowly and steadily how this session will cover each and every aspects related to IPR, copyright, and plagiarism. So friends, this is my very small friend. He had trademark his name. So now you will need to pay me to use it. It means if I some property in terms of intellectual with me, I can earn a money from that. So if there is a money, definitely every professional is interested. So IPR is somewhere related to the money. Power of IPR. See, the board of directors is explaining the profit and loss account. And MD stand up and he had mentioned this blank space. Here, there is an IPR of that person and he had taken from you. It means if I'm working with certain companies, I had my own patents. At any time, I can take it. Yes, if I want to leave that firm, at any time, I can take it. It means IPR can be with you at any time, at any moment. Do you remember this movie, De Dhakka? Yes, there was a part of the IPR covered in that movie. Yes, Makaran Anaspure had developed certain things to consume less fuel, and his brother-in-law had patented with the help of patent attorney. But he doesn't know that he had already patented. At the end of the film, he got good royalty amount due to patent. It means it can be protect your property. IPR is the concept where your intellectual property can be protected. This speed is okay, or should I go a little bit slower?
Yeah, it's good, sir.
Okay. And the language is okay, English?
Yeah, fine, sir. Fine, sir.
Okay, thank you so much. IPR in cinema. See, we are very much copying the westerns. Zindagi Na Mile Dubara. Actually, the image of that was copied from the Lords of Docton. Bahubali, the image of that picture, title of that image and a picture is copied from the Simon Bridge. So IPR is not only related to education, it's not only related to industrial, it is everywhere. It is everywhere. That's why we have to be very much aware of that. So we'll take a common example of a simple common man who is starting his life. When you start your day till the end of the day, IPR is related. How? हक से मांगो. What is that? क्या है वो? हक से मांगो. किसी को याद आ रहा है? इसको लगा डाला तो लाइफ जिंगा लाला. Anyone want to answer? इसको लगा डाला तो लाइफ जिंगा लाला.
टाटा स्काई.
Very good. हक से मांगो. हक से मांगो. ठीक है. जिंदगी के साथ भी जिंदगी के बाद भी.
LIC.
LIC.
Very good. दाग अच्छे है. दाग अच्छे. Very good. तो आप लोग, you had given me 3 answers. हक से मांगो, it is the tagline for the Priya Gold biscuit. See, here is the IPR importance. TIDS, tides, and TIDE. It will differentiate the originality. It will differentiate between the originality and the duplications. Then Colgate and Colgate, Coma and Puma. So IPR is really important to identify the originality of the product. So on 26th April, every year, we celebrate an Intellectual Property Day. My kind request to all the college authorities, those who are associate, those who are present here, you should create awareness. You should organize certain sensitive workshop or talk on this day on the IPR. So students will get to know the awareness of the IPR and they will try to implement certain things in their studies. Nowadays, universities, education academics are very much in, registering the pattern. So this awareness is really important. So World Intellectual Property Day is celebrated on 26th April every year. This is, I would like to inform you, what is this exactly? This I have taken from the International IP Index report. This is the India ranking in terms of the IPR. It is not only patent related, it is a whole branch of IPR. Where we are in 2019, we were 36, but in 2023, we were at 42. So somewhere we are lagging. So we have to give value. We have to create value. We have to create awareness about the IPR. Then only we can raise our standard in terms of IPR ranking. So what is the asset basically? Assets can be divided into 2 types. What are they? Assets can be divided into 2 types. Tangible assets and intangible assets. Tangible asset means the asset which can be seen. The asset which can be seen, that is called as tangible assets. A cash, equipment, machinery, physical plant, property, inventory. So a tangible asset is an asset that has physical substance. So what is intangible assets? An intangible asset is an asset that is not physical in nature. For example, goodwill, brand recognition, intellectual property, such as patent, trademarks, etc. So assets is divided into 2 parts, tangible and intangible. So what is intellectual property? IP is a category of property that includes intangible creation of the human intellect. So it can be considered as a property for selling purpose, for purchasing purpose, for lease or rent purpose, For pass, you can pass under wheel also, even you can assign to a person also. So such type of transaction can be done with the help of IP assets. What type of transaction can be done? It can be sell, it can be bought, it can be leased, it can be passed under a will, it can be assigned. Right? So we'll start with a story. How this IPR can be theft. There was an engineer who was working with a company, and he had left that job and he had joined to the B company. But on the same time, he had not disconnect with the earlier boss. So whenever he's getting time, he's going to the Xbox having a lunch. During the lunch time, the engineer had sharing certain things to him on a very casual note. But after 6 months, the new boss realized that they had lost 3 important contracts, and it was taken by the opposition. It was taken by the competitor. Because during that lunchtime, that engineer is passing certain information. It was not intentionally. It may be unintentionally, but that engineer was passing certain important IP information to that person, and he was taking the advantage of it. So this is the way IP can be theft. So why IPR is important? That is really important here. Intellectual property fraud statistics. See, it can be theft due to human error, it can be theft due to system glitch, or it can be theft due to malicious attack. So to protect all this, the IPR play a very important role, and we have to understand how we can protect our IP. That is important. So why IPR to be protected? For the economic growth and advancement, of course, to attract the investment, consumer protection, facilitates fair competitions, promote cultural diversity, revenue generation, globe trade. I guess all the points are very much clear with the title. Economic growth means for the betterment, for the development. Attract investment. If I have a good patents, I can attract investments. Consumer protection. Yes, definitely. Consumer can identify the originality of the product. That's called as consumer protection. It will facilitate fair competitions. Yes. If I have a very good product, no one can copy it. If I had a patent with the patent register, it will promote cultural diversity. Yes. Revenue generation and globe trade. So that's why IPR should be protected. So at the world level, who is going to manage all these things? There is the organization WIPO, World Intellectual Property Organization, signed at Stockholm on July 14, 1967, and as amended on September. What are the objectives of the WIPO? That is important. To promote what? To promote the protection of IP throughout the world through cooperations among states and where appropriate in collaboration with any other international organization. It means the first objective of the IP, of the WIPO, to promote and protection of the IP at the international level. Second objective, to ensure administrative corporations among the unions. Yes. Those who are associated with the WIPO, to ensure give administrative cooperation among the union. So these are the core objectives of the WIPO, which is to be maintained by the WIPO. Right. So what are the objectives of the WIPO? That is important. We will check one by one what are the objectives. WIPO aims to improve global intellectual property protection and harmonize national legislation. It will also manage Paris Union, special unions, and Bern Union, and promote international agreements. Then WIPO also collaborate with states seeking legal technical assistance and ensures information dissemination and publication. What are the main reasons why we want to protect the IPR? For the progress and well-being of humanity, for the legal protection of new creations, promotion and protection of intellectual property. These are the main reasons we have to protect IP. So Indian government Indian government, they had bring out with a policy. That policy name is National Intellectual Property Right Policy, which was launched in 2016, has created a robust economic system for IPR protection and promotion, leading to the establishment of specialized IPR cell. So it was Indian government who are thought that we have to create certain systems where we have to protect the IPR and promote, and it have to promote the IPR. So that's why they had created an IPR, that is National Intellectual Property Right Policy, which was launched in 2016. So what are the features of this NIPR policy? This policy emphasizes on the importance of innovation and creativity in a knowledge economy. Then it also proposed an IPR exchange to facilitate investment in IPR-driven industries. It also expedites patent application examination. This policy also prioritizes financial support for less empowered IP owners in rural and marginalized economies. The policy also emphasizes on the strengthening enforcement mechanism by enhancing coordination among government agency and non-government players. Other measures include criminalization unauthorized copying of movies, encouraging CSR fund, that is corporate social responsibility funds, and expanding IPR capacity building. However, the policy aims to promote IP as an end in itself, linking career progression and IP generation. So these are the features of that IPR policy. So IPR and Indian University. Indian universities have significant improved their intellectual property rights over the past decade with over 100% increase in the patent filings. So Indian university play a very important role in promoting and creating awareness of the IP. So why students must know about intellectual property? How students get to know about the intellectual property? Yes, the education system can integrate IPR in the curriculum. My kind suggestions to all of the academic gurus, they should include IPR subject in the curriculum, and it is already included. So again, another request to you, please arrange certain practical workshop, theoretical seminars, conference on the IPR for the students at the student level. So they will get to know the concept in a detail, and they will get to know the importance of that. Intellectual property, as I mentioned in my introduction, it is divided into two parts: industrial properties and copyright and other relating rights. So we'll just check one by one what are they. IPR in India, the important types of IPR in India. I will start with the design, industrial design, geographical indication, trademark, patent, copyright, trade secrets. So these are the core aspects of the IPR in India. So we'll just check one by one what are they. So we'll start with the what is industrial design. The art and science of improving the aesthetic ergonomics, functionality, and or usability of a product hardware. So industrial design can be applied for hardware, form, style, material, aesthetics. So it can be applied to industrial products, handicrafts, technical, medical instruments, watches, jewelries, housewares, electrical appliances, vehicles, architectural structure, textile design to leisure goods. So industrial design applied to all this category. So industrial design in India, yes, it is protected in India by the Design Act of 2000. Under this registration offers the proprietary copyright in the design. This includes design number, class number, date of filing in the country, the name and the address of the proprietary, and so on. So that's why if you want to protect any industrial design, you can go for a Design Act of 2000. So how do you frustrate an industrial design? Give them a project with no budget and unrealistic deadline. So it happens with the industrial designer. They get the project but with no budget, and the deadline is very less. So what next, friends? Yes, one of the important aspects of the IPR, that is patent. See, all others area are my competitor, but where I had my patents, that is my area. It means I can say this is my area where no one can come and infringe it. Oh, that is my idea. So don't stole. You can ask, you can stop that person. You're stealing my idea. So we'll start with a small story. Mr. Z explored and discovered a new land, and he went for a patent it. As he went, he found something new. While patenting his discovery, he received a patent strike. Authorities said that Mr. Z cannot patent as it is a discovery. So it should be invention, it should not be a discovery. So what is invent and what is discover? Somebody has to develop something that has never happened before. That is invention. Somebody has to found something which is existed for a long time but has recently found. That is called discovery. So this is a thin line difference between the invent and discovery. Invent you can patent, discover you can't patent it. So patent means monopoly right granted to a person by patent office to exploit his invention for a limited period, for a period of 20 years. Invention patentable if it is a new, if it is useful, it is not obvious, it is pertains to a patentable subject matter. The session is going in a good flow. I'm clearly audible. My presentation is clearly visible. Can somebody confirm?
Yes, sir.
Okay, thank you so much, because we are in an online mode, so I can't see you. So that's why I'm taking confirmation again and again. So patent in a simple way. In short, patent is for invention. Patent is for exclusive right. Patent is for limited period. Patent provided by the government to the patentee and in exchange of full disclosure of invention. It will exclude from others. It will exclude from others for making, using, selling, importing the patented product or a process producing that product for that purposes. So these are the way you can protect your invention. So benefits of patents. Offering the patent for sale, you can offer, you can protect the inventions, you can donate a patent, you can claim for the patent infringement, you can license the patent also. These are the core benefits of the patents. So patent infringement is what? Violation of the exclusive right by a patent holder. By violating patent rights, and inventor has an invention by making use or selling device without the patent owner permission. If I am violating, it means I have not taken any permission from that patent owner and I am using it. That is called infringement. So patent infringement can be happen in two ways: direct patent or indirect patent. So what is direct patent and what is indirect patent? That is important. So what is direct patent? Direct infringement means what? It will directly copied. The design will be copied, process will be copied, and it can be used for a sell or use or a sell patented invention without authority. Indirect patent occurs when a party induces another or to infringe without directly infringing the patent. I'll just get the idea from that product and I'll make my own product. Even you're copying that idea is also patent infringement. Further, direct patentation, it may be a lateral or a DOE. In indirect patent infringement, it may be a contributory or inducement. These are too technical, so I'm just going with the term, and it is not required to go in a detail. So what is patent process infringement? A product can be patent infringement, but even a process can also infringement. If I'm creating certain product with a specific process, if somebody is copying and creating another product, that is called patent process infringement. So in this also, we can also patent or process. So we can also protect our patent process also. Why did inventor keep this patent in the freezer? It is a joke purpose. He wanted to make sure it was a cool idea. So don't take it in a wrong way. It is a joke. What next? Any idea? Trademark. What is trademark? A trademark identify company to the customer. Customer know the trademark. They have learned to trust that the company makes good product. Mr. X, another story, decides to open a company. and he want to name a company. He want to name a company, logo of a company. So African does Steve Jobs. He as soon as he want to give this name and he want to use this logo. As soon as he started company, he received a trademark strike. Court verdict: Mr. X should immediately change the name and logo of a company because it is already assigned to another person. So if you copy anyone company's name or a logo, your trademark will play an important role. A trademark, properly known as a brand name, in layman language, it is a visual symbol which may be a word, signature, name, device, label, numeral, or combination of color. It is distinguished it from other similar goods or services. Legal compliance required to register a trademark, geographical representation. It should be distinguished, connection between the goods and services. TM symbol can be used next to the logo. Example of trademark: see, McDonald, they had trademark logo. Patanjali, they had trademark name. Slogan: Nike, they had trademark slogan. Shape: Coca-Cola had trademark the shape of the bottle. So this is the way you can trademark your product. Just give me 1 minute. There is certain disturbance from my end. Just give me 1 minute.
Hello, Jadhav sir. Hello. So you're not audible.
I'm audible now?
Yes, sir. Yes, sir. Audible.
There were certain disturbance. Wait a moment. I'll just share my screen. Confirm me whether it is visible.
Yes, sir.
Yes, sir.
Okay. Sorry for that disturbance. Under modern business condition, a trademark performs 4 functions. What are they? It identifies the goods or services and their origin. It guarantees its unchanged quality. It advertises the goods or services. It creates an image for the goods and services. So these are the core functions of a trademark. These symbols generally we find it at the upper side of the product. What are they? If it is R with circle, it means used with USPTO registered trademark. It means it had clear all this process and it is registered. The second one is TM, used with trademark not yet registered. They had applied, but they had not yet got the registered trademark so far, but they had applied. SM, used for a service mark, not yet registered. So this is the way we can identify the process. Example: trade name. Trade name is the legal name of the company. For example, Reebok, right? So trademark versus trade name. Trade name identifies a company or a business. A trademark identifies a goods or service. For example, the Coca-Cola company, the name of that company is Coca-Cola. The symbol, the logo, it is like Coca-Cola. Purpose of the trademark and trade names. Trademark, it will identify product or service. Trade name, it will identify business or a company. Trademark, customer buy trademark. Customer do business with trade names. So customer buy trademark from trade names. There are certain important things which is trademark in India. What are they? For example, First building in India to get trademark, that is the Taj. What does it mean? Cannot be used for the commercial purpose. Yes, the Taj Hotel, they had trademarked their structural design. Others, Bird Nest Stadium, Eiffel Tower, Sydney Opera House, Empire State Building, and Burj Khalifa, they all have trademarked their structure. So what is collective mark? Marks being used by a group of company can now be protected by the group collectively. The owner of such marks may be an association, public institution, or a cooperative. Then what is domain name? A domain name could be said to be a word or a name which can distinguish the subject of trade or service, which is made available to potential user of the internet. A domain name may have all characteristics of trademark. So for example, if you register with the trademark, if you register with the domain name, even you can go for the registration, the same domain name for the trademark also. How do trademark prevent the jokes from being stolen? They copyright them. It's a joke. So what is our next aspects of the IPR? Any idea? Geographical indication. It indicates that particular goods originate from particular nation or a geographical area, locality, and has some special characteristics, qualities, or a reputation which are attributable to its place or origin. The special characteristics, qualities, or reputations may be due to various factors. Example, natural factors such as raw material, soil, regional, climate, temperature, moisture, etc., or method of manufacturing or preparation of the product. How long has India it? India had passed Geographical Indication of Goods Registration and Protection Act in 1909, which came into force in September 2003. So far, Madhya Pradesh Ratna Salam Save, Gujarat Gir Kesar Mango, Maharashtra Strawberry. There was a huge fight between West Bengal and the Orissa for the GI tag of Rasgulla. But at the end, if I'm not wrong, Orissa had won that battle and they have got that. So how do you treat in a geographical indication? Make sure everything is locally sourced or the party can't start. So this is a joke. You can take it in a joke way. What is next, friend? That is important. We have to discuss here. So we'll check what is next available for us. Yes, the sign resembles, that is the copyright. So we'll start with the copyright. Here is the small story. Mr. Y, artist, decide to make a short film. He has a very good story. He made the film. The film is based on Indian swag. So he added a song, Swag se karenge sabka swagat. So while uploading the film, he received copyright strike. Why? Because Mr. Y cannot upload as he had added the song, which is already copyrighted. So it means if you're using any copyright material at any time, a strike can be happen to you. So the beauty of copyright law is it protects you. It provides you the opportunity to honor the other. Best memory of my school life, notes copy करते समय ये क्या लिखा है बे, जो समझ में आ रहा है वही लिख, बाकी ऐसे ही डिजाइन बना दे. So this happens. नकल में भी अकल की जरूरत होती है. Copyright, it is intellectual property. It is an exclusive right for literary, musical, and other artistic works, including films, sound recording, computer software, etc. So what are the legal frameworks for the copyright? For the protection of traditional beneficiary of copyright, for the individual, author, composer, or the artist. Moreover, also for the investment required for the creation of works by major cultural and other industries. So these are the legal framework of the copyright, which provides legal framework to your work. There are two conventions. Paris Convention, it happens due to protection of IP. It happens in the 1883, right? So Paris Convention main aim is to, Paris Convention is one of the intellectual property treaty administered by the WIPO, World Intellectual Property Organization. It was launched in 1883 in order to provide what some international harmonizing and streamlining of intellectual property law. There are 169 members so far in that treaty. The another Berne Convention, it is specifically for the protection of literary and artistic work, and which is signed in 1886. Right. This convention was adopted in 1886 to protect the creation and the rights of the creators in the international arena. Nearly 180 countries signed the convention regulated by the WIPO. It lays down the ground rules on how to creators of the literary and artistic works can have control over the usage of their creation. Fundamentally, this convention was formed to tie the laws of different nationals into a single platform with minimum standards to protect copyright creation. So key features of Berne Convention inclusive of literary and artistic works, books, pamphlets, writing, lectures, address, sermons, a scientific or artistic domain, dramatic, musical, choreographic work. This will be covered. Musical composition with or without works. It will be covered. Works of drawing, painting, architecture, engraving, and lithography, photographic works. It will be covered. Work of applied art, illustrations, maps, plans, sketches, 3D work. This all work will be covered in this Berne Convention. So works protected under copyright. That is really important. So we'll check one by one what are the works protected under copyright. Dramatic literary work, dramatic work, computer programming, musical work, artistic work, sound recording work, cinematic film. So literary work, example, school textbook, head notes, commentaries of the act, judgment, who is the owner, writer, term of the copyright, lifetime of author plus 60 years. The next category, dramatic work, example, drama, play, excludes cinematic film, owner, creator of the work, term of copyright, lifetime of author plus 60 years. The next category, musical work, musics and includes any graphical notations. The song is not musical work. Who is the owner, creator of the work? Lifetime of author plus 60 years for the term of copyright. The next one, artistic work, a painting, work of architecture, work of artist craftsmanship. This will be covered in artistic work. Who is the author? Artist of the work. In case of photograph, the photographer will be the author. Terms of copyright, lifetime of author plus 60 years. In case of photograph, it is a 60 years from the year subsequent to the year of publication of that photograph. Sound recording means a recording of sound on any medium from which such sounds may produce. For example, producer of the work, author is the producer of the work. Term of copyright, 60 years from the year subsequent to the year of publications of sound recording. The next category, film. Film, animation film, video film. Who is the author? Producer. Term of copyright, 60 years from the year subsequent to the year of publication of the year. Film, sorry. The next category is broadcasting production right. Means communication to the public by a wireless diffusion or by wires, one or more form of sign, sounds or visual images. Who is the author? The organization who broadcasted the author. What is the term of copyright? 25 years from the year of broadcast. Performer right? Yes. The performer may be actor, musicians, jugglers, acrobat, a person delivering the lecture, snake charmer, and a dancer. Who is the author? Performer of the work. What is the term of copyright? 50 years from the year of performance. So generally, what are the rights of the copyright owner? So you should know your rights. So what are the rights for the copyright owner? There are two types of rights available for the copyright owner. What are they? Economic rights and the moral rights. Economic rights, right to replication, right to make work under the public. These are the economic rights. Moral rights, right to making the work publicly, right to determine the indications of the author name, right to preserving the integrity, author's honors, popularity. So these two rights are available for the copyright owner, economics and moral. What is the copyright infringement? If someone used your work without giving you credit, that is called as copyright infringement. It may be for the sell purpose, hire purpose, or offer to sell. It can be distributed copies for the commercial purpose. It will exhibit in the public. Import into India any infringement copy. So this all scenario can be considered as a copyright infringement. But in copyright, there are two important things you should know: fair use and public domain. So how to avoid copyright infringement? Fair use and public domain. So fair use, it is acceptable at certain limitations, and the public work, which is also accepted, but it should be in the public work. So work used under fair use are still covered by the copyright, but works used in the public domain are not covered by the copyright. Part of work may only be used for the fair use purpose, education purpose, research purpose, news reporting. In public domain, allow entire work you can use without with change, adaptable or other media. In fair use, permission needs to be obtained to sell or distribution of the entire work. In public domain, permission is not needed to sell or publish the entire work. In fair use, you have to give the credit to the original owner. In public domain, credit is not required. So Copyright Act, Copyright Act 1956, which is really old, it is amended 5 times. In 1983, its first amendment for the broadcast technology and reprographic technologies. In 1984, second amendment due to technology like printing. In 1994, due to medical textbook, Pagiarism medical textbook, it is amended. And in 1999, due to conform of the trade aspects. So earlier it was 4 amendments, but in 2012, the most substantial amendments happens. The amendment name is the Copyright Amendment Act 2012. What are they? There are a lot of changes happened in this Amendment Act. They had introduced commercial lender amendment of section 2 after clause F. The following clause should be inserted, namely FA, commercial lender, which can be termed as a welcome change. Commercial renter referring to a symbolic frame, which includes rent can be happen, lease can be happen, lending to a lawfully acquired copy. It means film which is acquired by me, I can rent to any other person. Then, what are other important things which happen in this clause? Four principles used to determine the fair use. What are they? The purpose and the character of your use. Second, the nature of the copyright work. Third, the amount and sustainability of the portion taken. Fourth, the effect of the use upon the potential markets. These 4 points are clear, then you can term it as a fair use. So fair use in 2012 Amendment Act, in general context, subsection 1, clause A, a fair dealing with any work not being a computer program for the purpose of research, criticism, reporting of current events, it is allowed under the fair use. Storing of any work in any electronic medium for the purpose of the mention in this clause, it is also allowed. Fair use for the digital work and electronic transmission or communication. Subsection 1, clause B. Electronic link access or integration is allowed under fair use clause. Subsection 1, clause C. Notice and take down procedure. If you got notice and due to copyright infringement, the new clause was inserted, new clause C of section 52. If you receive written complaint received from the owner, then it should be removed. If you are not received any complaint, then you can continue without any problem. For judicial proceedings, fair use, subsection 1, clause D, reproduction of any work for the purpose of judicial provision and reporting, it is allowed under fair use. For education institute activities, yes, subsection 1, clause J. The performance in the course of activities of educational institute, it is allowed under fair use. For digitization of library, yes, in subsection 1, clause N, public library to store any electronic copy of a work which is already have a physical copy, storage shall be for a preservation purpose. It is allowed for the preservation purpose. Technical drawings, yes, it is allowed under the fair use clause. Subsection 1, clause W, engineering or medical devices, making of 3-dimensional object from 2-dimensional object, it is allowed under the technical drawings and it can be considered as a fair use. If a person with disability, yes, in this also fair use is also allowed. New clause is added, that is ZB has been added to the clause 52.1. It provides adaptation, reproduction in any accessible format to facilitate person with disability. It is mainly for education purpose. It is allowed. Even these rights are available to any person or organization who are working for the benefit of the person with disability. So this can be done under the previous clause. The new section 31B was introduced. There should be a compulsory license for those who are working for the benefit of the disabled person. Digital right management, a new section 65B is inserted in this amendment, and it is for the digital right management. To protect a digital copy, it is inserted. Insertion of new section 65B, any person who is removing DRM or remove or alter any rights management information without authority, that can be punishable of 2 years, and fine also punishable. These all are the welcome changes, but what are the worrisome changes which was happened in Copyright Amendment Act 1957 in 2012? The copyright terms, the duration of all the copyrights are above the minimum required by our international obligation. The term is really more if you compare with the international obligations. Missed opportunity, fair dealing guideline. They doesn't provide the detailed fair dealing guideline. They doesn't have any list of education exception. They failed to communicate to the public. They had not involved internet intermediary. Even small users and small creators left out of declaration during the amendment. For example, libraries, consumers, historians, teachers, they had ignored all this small category of people. So now the last part of the session, that is plagiarism. What is plagiarism? A very important topic if you ask me in terms of academic community. We'll start with a story. A and B are a very good friend. B attempts to steal A cats. He succeeds. But at the end, he got caught. What important lesson he got here? The important lesson he got here is you can take another work, another things, another person things, but for that you have to take the approval. For that you have to take the approval. So that is the important thing he had learned. The same thing continues. The same story continues. B had successfully stolen the cat of A, and he went out. Somebody asked him, whose cat it is? He had lied. He said, it is my own. This year, he got a very important lesson. You can take somebody else's work, but you have to tell the truth to the people. So conclusion of this story, you can borrow other people's work as long as you had asked and taken the permission, as long as you had given credit to that person from whom you are borrowing it. It is not your own stuff. You shouldn't tell people that it is your own. You need to take the permission and you need to give the credit to that person. So what is plagiarism? In other words, it is a copying information and not giving credit to the author. In short, in a very simple way, it can be termed as a theft, it can be termed as a cheat, and if you got caught, the result can be 0. So in short, plagiarism is really wrong. What consider plagiarism? Presenting another works without as your own, using words and phrases without giving credits, not using quotation mark properly, giving incorrect information about the cited sources, copying such large amount of ideas, words that is majority is not yours. Then what are the excuses generally we get from the students? My teacher expect too much, that's why I'm copying. I have to get into certain colleges, that's why I'm copying. It's okay if I don't get caught, that's why I'm copying. Everyone does it, that's why I'm doing it. My parent expects A+, that's why I'm copying. So these are the general excuses we are getting from the students. So what are the common type of plagiarism? I'll start with a very brief. Accidental, it may be unintentional or intentional. कोई जानबूझ के करता है, कोई गलती से करता है. So these broad 2 types of plagiarism happen. Now we will go into technicalities of the different types of plagiarism. Clone means what? Submitting another word for word as your own. This is the first type. Control C contains significant portion of text from a single source without alteration. This is the second type. Find and replace, changing the keywords and phrases but retaining the essential content of the source. This is the third type. Remix, paraphrases from multiple sources made to fit together. This is the fourth type. Recycle, borrow generously from the writer's previous work without citation. Sixth type. Hybrid, combine perfectly cited sources without copying passage without citation. So this is the sixth type. Mashup, mixes copies material from multiple sources. 404. Include citation to non-existing or inaccurate information about the sources. This is the eighth one. Aggregator, include proper citation to sources, but the paper contains almost no original work. Rewrite includes proper citation, but relies too closely on the text originally wording add or structure. So these are the common technical types of plagiarisms are there. So there are a lot of confusion in the mind of the students. So what are the confusion? We'll just clear it here. Alive or dead? Yes. If you're taking somebody's work who is alive or dead, it doesn't matter. If it is not your one, you have to give credit to that person. Free? What about all that free stuff people put on the web? Can you use it? No, free means economically. No, free means economically free. You do not have to pay for it. The free stuff has a specific use and can only be used free of the intended use. If you use the words paragraphs, then you have to give the citation. So if you're using free stuff, you have to still give the citation. Permission granted still. Sorry, you cannot use someone else's paper, artwork, or presentation without proper citation, even if you have a permission. Instead of permission, you should also give credit to that person. Can I hand up my essay on Friday, Miss, because my ghostwriter is unveiled? So such things happen in the academic. Okay. Remember, if you can find it, so can your professor. Yes, there are many sites that will sell you an essay or a term paper or project. Presenting this material as your own, it is a plagiarism. Some of the papers for site do you have disclaimer. So please don't purchase, don't take it from the web by paying the cash. Paraphrase requires a citation. Of course, it requires a citation. If you translate or paraphrase something, you must still give a citation to the original one. The lecture by your professor, of course, you have to cite. If it is an oral lecture, if it is a visible lecture, anything, if you are taking idea from that professor, you have to cite. Common knowledge, yes. Common knowledge consists of information that is easily observed, commonly reported facts, common saying. Common knowledge does not need it to be cited, but the sure that who you are using really common knowledge. When in doubt, ask either your instructor or a librarian. This is the era of open AI. Recently, there was an article open artificial intelligence platform in nursing education, tools for academic purpose, for progress and abuse. Though there were two authors, one is human, another one is ChatGPT. So what is that? ChatGPT is banned by the French university or plagiarism concern. Yes, in some of the university in India also it is banned. So please don't take word by word from the ChatGPT. So UGC, University Grants Commissions, had taken various measures to stop plagiarism. How? They had come up with a regulation. That regulation come up in 538th meeting held on 20th March 2018. The name of the regulation is UGC Promotion of Academic Integrity and Prevention of Plagiarism in Higher Education Institution Regulation 2018. Objective of the UGC regulation: creating awareness, prevention of misconduct, establishing an institutional mechanism, promotion of academic integrity, prevention of plagiarism, and setting up a system for catching plagiarism. These are the core objectives of the committee, of the regulation. What is the definition under this regulation? The definition of plagiarism, which was defined in section 2, subsection 1 of the UGC regulation. Plagiarism means practice of taking someone else's work or ideas and passing them as your own ones. Script in this regulation: research paper, thesis, study, project report, assignment, dissertation, and any other such work submitted for assessment opinion leading to the award of degree or publication in print or electronic format by student or faculty or staff of the instruction. As per regulation, exam scripts are exempted. So restricted to the HEI. What is HEI? Higher education institute, which are as follows: universities or any institution. This regulation restricted to university or any institution that has been declared by the parliament to be a national importance, or institute that provides certification education after 12 years of schooling and which provide degrees or diploma. So this regulation applied in these three categories. What is the duty of HEI? That is higher education duties. It should establish a mechanism for spreading awareness. It should organize seminar about in students among the and faculty members. It should also incorporate academic ethics in graduate and postgraduate coursework. It also teach research and publication ethics in the coursework. It should provide training to use different software can be used for the detection of plagiarism. It also establishes and facilitates for checking the plagiarism. What is exempted by this regulation? Quoted works, similar content up to certain extent, standard equations and symbols, and all references, table of content, preface, acknowledgement, and bibliography. This is exempted by this regulation. But there is a zero tolerance policy in which area of your paper or thesis or your research report. So zero tolerance area are the hypothesis, recommendation, abstract, summary, conclusion, results, and observation. These all areas are the zero tolerance. So UGC regulation detection and reporting, how it will work. There are two panel. One is first is DAIP, that is Department Integrity Panel. The another one is Institutional Academic Integrity Panel. First, DAIP will investigate matter and submit its report to the IAP, and then IAP will submit its report to the higher education institution. So what level of plagiarism have been quantified in this regulation? And what is excluded? So up to 10%, if your thesis is up to 10%, it is excluded. From 10 to 40%, level 1 charges will be applied. From 40 to 60%, level 2 charges will be applied. And above 60, level 3 charges will be applied. So what are the level of charges is determined in this regulation. So UGC regulation penalizes in case of plagiarism. They had defined for both the category, for the student category and for the faculty. Up to 10%, no penalty for students, no penalty for the faculty. From 10 to 40%, that is level 1, 2. Sorry, level 1. Yeah, that is the level 1. 10 to 40%, yes, level 1. Revision of script in 6 months. One moment, I got a call. Just to give me 1 moment. Hello. Yes. Actually, I'm in one of the meeting, HR meeting. Can I give you a call within half an hour? That's fine. Sorry for that. Sorry for that. I'm in one of the important meeting here. Yes. For faculty, from 10 to 40%, he has to withdraw the manuscript. It means there is a strict punishment for the faculty. In 40 to 60%, the student can't submit revised script for 1 year. In case of faculty, it is 40 to 60%, no supervision for that person for 2 years. Or 60% cancellation of registration for the student. Or 60% in faculty, no supervision power for 3 years. So these are the charges which is applied in the regulations. Suppose if HEI is accused of plagiarism, definitely the guideline will also provide appropriate shall be taken action against the HEI. So no one is allowed to misuse of this regulation. Self-plagiarism, what is the self-plagiarism? UGC, University Grants Commission had clarified with the public notice that self-plagiarism is not allowed, and they had issued a public notice on 28th April 2020. Reproduction, text recycling or self-plagiarism without quotation, citation, and proper acknowledgement, it is not acceptable. It can be considered as a self-plagiarism. Even if I'm using from my own paper, I have to quote for myself. I have to give credit to myself. Otherwise, it will become under self-plagiarism. So what are the software which is used for the anti-plagiarism software? What are they? Software that searches the web for duplicate textual content. It may be a standalone program installed in the user computer or a function of a website. So detection of plagiarism with the software, what are they? Definitely, earlier in print area, it may be difficult, but technology make it easier. Search engine can easily detect. Free and commercial tools are available for detection. So we'll check free first and then commercial. Free, this is the paid one, sorry. Grammarly, Turnitin, Orkun, Plagiarism detect.org, Authenticity. These all are the paid one. And this is the taken from the live demo from the Grammarly. So this will show you the paragraph from where it is copied and how many percentage it is. So how to avoid plagiarism? Friends, you have to use three strategy: quotation, cite properly statistics, charts, graphs, and drawing. And if you are paraphrasing, please cite it. If you are summarizing, please cite it. There is a thin line between the copyright and the plagiarism. Copyright is a legal term, plagiarism academic term. Copyright is a civil crime, plagiarism is an academic crime. Plagiarism, unauthorized use of someone else's creative work. Plagiarism, claim ownership of someone else's work as your own. In copyright, monetary damages for infringement. In plagiarism, not punished by the government, but academic sanctions can be cancelled. So this is the joke part. Hey, Malik Tere Bande, the owner of the song came, first pay my royalty, then only you can beg. So common question about plagiarism, except when you use your own words, when the facts using the common knowledge. These are the common. Do you have cite everything? No, it is not required if it is in the common language, and if you are using your own words, it is not required. Abhi दिखाना language change करूंगा. This is happens in the Hollywood and Bollywood. So friends, what are the education institutes should be creating the awareness with the help of national IPR policy? They should strengthen IP infrastructure. They should attract investment, make environment business friendly, autonomy, faster IP process, reviewing rules and procedure. I would request academic institutes to hire someone who can be easily available for them for the registration process of the patent, trademark, etc. So this is my kind request. This is my conclusion to the. You should have IPR cell to organize group meeting, lectures, to take IPR audit, to guide the inventors, to facilitate IP management. So this IPR cell provides a very insightful and helpful hand to the education institution. 3 tips: protect your institution, faculty, staff, and users. Establish a campus-wide fair use policy. Read and negotiate license for digital contents and educate your campus. That will be the important strategy to avoid any IPR infringement. If there is questions, I'm happy to answer your queries. Please shoot your question. I'm there.
Thank you so much, sir. If any question or any query regarding that IPR, copyright, and plagiarism, students may ask. If you have any questions from student side regarding the plagiarism, because most of the students from LLM second year and they're doing dissertation or research project. If you have any query regarding that plagiarism, how to avoid the plagiarism, you can ask to the resource person. Sadhu sir, I think there is no any question
Hello.
from students end.
Hello.
Yes, there is something
Yes,
from.
yes.
Hello, sir. I'm audible.
Yes, you're audible.
Sir. First of all, I like to appreciate you. Your आज जे काही तुम्ही सर लेक्चर दिलेलं आहे तुमची लँग्वेज आणि तुम्ही एवढं सुंदर पद्धतीने सांगितलेलं आहे की आमचे बरेचसे डाऊट क्लिअर झालेले आहेत. पण माझा
थँक्यू
एक
सो मच. मला बरं वाटलं ऐकून.
माझा एक सिंपल असा क्वेश्चन आहे सर की
बोला.
ज्यावेळेला आपण कुठल्याही कॉपीराईट इन्फ्रिज होतो त्यावेळेला आपण जेव्हा कंप्लेंट करायला जातो तेव्हा मोस्ट ऑफ टाइम आपल्या हे असं लक्षामध्ये येतं की ती जी आपण कंप्लेंट राईज करतो आता मोस्ट ऑफ टाइम कसं होतं की एखादा ट्रेडमार्कचा आता तुम्ही घ्या एखाद्या कंपनीमध्ये डुप्लिकेट ट्रेडमार्क ज्यावेळेला यूज होतो ठीक आहे, किंवा
हा.
एखादा पॅटर्न जेव्हा इन्फ्रिज होतो, आपण ती जर कंप्लेंट राईज करायला गेलो, तर ती
हा.
प्रोसेस कशी असावी, किंवा त्याचं ज्युडिएक्शनचे जे मोस्ट ऑफ टाइम जे प्रॉब्लेम्स येतात, ते कसे आपण सॉर्ट आउट करावे?
ओके ओके ओके. मी तुमचा प्रश्नाला खरंच म्हणजे खूप चांगला प्रश्न असेल आणि हा इंटर रिलेटेड प्रश्न आहे. मला बरं वाटलं. मला ऍक्च्युली पहिलं वाटलं की कोणीच प्रश्न नाही विचारणार आणि मग मी संजय सॉरी सालुंके सरांना बोलणार होतो, सर हेच दुर्भाग्य असतं ऑनलाईन मोडचं. म्हणून मी त्यांना पहिलाच प्रश्न बोलतो की आपण ऑनलाईन मोड नको करायला, कारण आता कोविड गेलेला आहे. काम करायची पद्धत वेगळी झालेली आहे. ठीक आहे, पण मॅडमचा प्रश्न खूप चांगला होता. प्रश्नाचं उत्तर द्यायच्या अगोदर मला तुम्हाला एक इन्सिडेंट शेअर करायचं आहे. फोटोग्राफर जे इमेजेस तुम्ही वापरतात, बरोबर आहे, नेटवरनं तुम्हाला इमेजेस वगैरे भेटतात, याच्या मागे एक बिझनेस मॉडेल आहे. तुम्हाला माहित असेल तर नाही माहित नाही, मी सांगतो तुम्हाला. जे कॉपीराइट इमेजेस असतात, जे ओनर असतात, ते काय करतात, पहिले फोटोग्राफ काढून घेतात, चांगले 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 इमेजेस काढून घेतात आणि ते त्यांच्या पेड वेबसाईटवर ठेवतात, राईट. आणि ते बघतात की
राईट.
बिझनेस कसा चालू आहे, काय चालू आहे. आणि जर त्यांना असं वाटायला लागलं की बिझनेस कमी येतोय आमच्या इमेजेसला, मग ते काय करतात, एक डुप्लिकेट वेबसाईट बनवतात, बरोबर आहे. आणि त्या
बरोबर.
डुप्लिकेट वेबसाईट मध्ये हे सर्व कॉपीराईटचे इमेजेस असतात ना, ते तिकडे पास ऑन करून टाकतात आणि 6 महिन्यासाठी गप्प बसतात, काहीच करत नाही, बरोबर आहे. 6
बरोबर.
महिन्यानंतर काय करतात, ते एक सॉफ्टवेअर असतं त्यांच्याकडे, ते जेवढे इमेजेस त्यांनी कॉपीराइट इमेजेस फ्री वेबसाईटवर टाकलेत, ते रिव्हर्स इमेज म्हणून एक सॉफ्टवेअर असतो, तो ते सर्व इमेजेस त्याच्यात चेक करतात की ह्या कुणी कुणी युज केलेले आहे. मग ते बघतात की समजा आता त्यांचे जे कॉपीराइट इमेजेस होते त्या 100 ठिकाणी वापरले गेलेत, बरोबर आहे. पण त्या
ओके.
100 ठिकाणी मध्ये 25 ठिकाणी एज्युकेशन पर्पज साठी वापरले, मग ते त्याने 25 ठिकाणी काढून टाकतात, त्यांना त्यांच्याशी काही घेणं देणं नाही. 25 ठिकाणी ते बघतात की हे एनजीओनी वापरले गेले, म्हणजे जिथं नो प्रॉफिट नो लॉस, बरोबर. मग त्यांना पण ते इग्नोर करतात. 25 ठिकाणी ते बघतात की गव्हर्नमेंटनी त्यांच्या काय प्रोजेक्टसाठी वापरले गेले, म्हणजे गव्हर्नमेंटनी काय प्रमोट करण्यासाठी ते इमेजेस वापरले गेले, मग तिथे पण ते सोडून देतात. पण 25 ठिकाणी त्यांना रिअलाइज होतात की त्यांनी ते जे कोणी वापरले त्यांनी कमर्शियलायझेशन साठी वापरले. आलं का लक्षात? मग ते काय करतात, त्या 25% केस स्टडी बनवून इव्हॅल्युएट करायला घेतात की ह्याचा मॉनिटरियल किती डॅमेज झाला, एक अंदाजे एक व्हॅल्युएशन करतात की एवढं एवढं मला डॅमेजेस झाले. मग तेव्हा ते केस फाईल करतात. मग त्याच्या हिशोबाने ऍक्च्युली बघायला गेलं तर एक बिझनेस झालाय. सेम फॉर अ ले पर्सन, जे तर ट्रेडमार्क इन्फ्रिज झाला असेल किंवा कॉपीराइट इन्फ्रिज झाला असेल, पहिलं त्यांनी हे चेक केलं पाहिजे की तो कमर्शियली कुठेतरी गेलाय का. हा ठीक आहे, जर तुम्हाला एक म्हणजे एक एथिकल वे मध्ये तुमचं प्रोटेक्ट करायचं असेल आणि तुम्हाला आढळलं की तुमचं कॉपीराइट मटेरियल कुठेतरी वापरलं गेलंय, तर तुम्ही एक सिंपल नोटीस देऊनही ते थांबवू शकता. पण ते कुठेतरी कमर्शियल वापरलं गेलं तर आय वुड रिक्वेस्ट यू, गो फॉर अ प्रॉपर प्रोसेस. प्रॉपर पद्धतीने तुम्ही कंप्लेंट रजिस्टर करा आणि तुम्ही त्याचा मोबदला घ्या. आणि त्याची प्रोसेस एकदम सोपी आहे. तुम्हाला पॅटंट एजंट, कॉपीराइट रजिस्ट्रेशन मध्ये किंवा ट्रेडमार्क एजंट्स हे जे लोक असतात हे त्याच्यामध्ये एक्सपर्ट असतात, हे तुम्हाला फाईल करून देतात. मी तर तुम्हाला बोलतो की तुमच्यापैकी काही लोकांनी हे जे एजंटचे कोर्सेस असतात ते कंपल्सरी करावं. जेव्हा तुमचं शिक्षण लॉचं चालू असेल तर त्यातनं तुम्हाला जो प्रॅक्टिकल बॅकग्राऊंड आहे ना त्या फायलिंग प्रोसेसचं, ते सोपं पडेल. आणि या प्रकारे तुम्ही रजिस्ट्रेशन जर झालं असेल तुमचं एखादं कॉपीराइट आणि ते कुठंतरी इन्फ्रिजमेंट झालं असेल, तर तुम्ही ती फाईल करू शकता अशा प्रकारे. हो मॅडम, मी तुमच्या प्रश्नाचं उत्तर दिलेलं आहे.
येस सर, येस.
अजून काय?
Yes. Any questions? Yes, Saloni, you please. Yes, Saloni. One question. If plagiarism is committed, is there a way that we can amend it?
काय बोलला सर? एक
Uh,
मिनिट.
एका स्टुडंटनी
So I
प्रश्न
have a
विचारलेला
question.
आहे.
If plagiarism is committed, is there a way that we can amend it? Of course, तुम्हाला जेव्हा plagiarism report तुमच्याकडे येतो, त्या रिपोर्ट मध्ये क्लिअर कट तुम्हाला आयडेंटिफाय केलं असेल की कोणत्या पॅराग्राफ मध्ये यू हॅड पॅराग्राईज आणि ते किती पर्सेंटेज, तर तुम्हाला ते रिराईट करता येतं. पण माझं सजेशन असं एक आहे की तुमचा रिसर्च पेपर असू दे किंवा थिसिस असू दे, सतत प्लॅगरिझम चेक करत बसू नका. चॅप्टर वाईज जर थिसिस असेल तर चॅप्टर वाईज करा आणि 2च अटेम्प्ट द्या, कारण तो सॉफ्टवेअर तुमचा कंटेंट कॉपी करतो आणि फ्युचरमध्ये तो तुमचा कंटेंट तुम्हाला असं दाखवतो की ते तुम्ही पॅलग्राईज केलेलं आहे. ऍट द एंड ऑफ द डे ते AI वर काम करतं. तर माझं असं रिक्वेस्ट आहे, जर तुम्ही थिसिस चेक करत असेल तर 2दा चेक करा, तिसऱ्यांदा डायरेक्ट फायनल करून चेक करून सबमिट करा. आणि पेपर जर असेल तर 2दा चेक करा आणि तिसऱ्यांदा डायरेक्ट सबमिट करा. डेफिनेटली तुम्हाला तो ऑप्शन देतो, पण जास्ती असेल तर तो तुम्हाला रिजेक्ट करेल, पण कमी पर्सेंटेज मध्ये असेल तर तुम्ही रेक्टिफाय करून सबमिट करू शकता. सोनाली मॅडम, आय गेस तुमच्या प्रश्नाचं उत्तर दिलं असेल मी. इथे कोणीतरी सर प्लीज शेअर पीपीटी म्हटलेलं आहे. सर सर्व काही नेटवर अवेलेबल आहे. माझा पीपीटी पाहिजे मीही तुम्हाला शेअरेबल आहे, काही प्रॉब्लेम नाही. कधी पण मला तुम्ही मेल टाका, मेसेज करा, मी तुम्हाला पीपीटी शेअर कराल, त्यावेळी काही प्रॉब्लेम नाही. इंटरॅक्शन करा सर, इंटरॅक्शन केल्यामुळे डाऊट्स क्लिअर होतात. फक्त कंटेंट घेऊन काही फायदा नाही, इंटरॅक्शन व्हायला पाहिजे. तुमचा आवाज येत नाही मॅम. कोण एनी अदर क्वेश्चन्स?
हॅलो सर.
हा बोला.
सर, जर आपल्याला इंटलेक्च्युअल प्रॉपर्टी राईट मध्ये जर करिअर करायचे असेल तर म्हणजे त्याचे गुड सोर्सेस काय आणि त्याच्या ऑपॉर्च्युनिटी काय आहेत?
मॅडम, व्हेरी गुड क्वेश्चन अगेन. जसं मी प्रत्येक लॉयरला एक सजेशन देतो की मी एक लॉ फर्म मध्ये आज 20 वर्षापासून काम करतोय, माझ्याकडे इंटर्न्स येतात किंवा फ्रेशर येतात ना, तर मी त्यांना एकच बोलतो की तुम्ही यू शुड स्टार्ट युअर करिअर विथ द लिटिगेशन. लॉयरनी जे लिटिगेशन फील्ड बघितलं ना, तर त्याला सर्व काही जमेल. तसंच आयपी मध्ये तुम्हाला जर तुमचं करिअर सुरुवात करायचं असेल ऍज अ पॅटंट अटर्नी, ऍज अ ट्रेडमार्क अटर्नी, ऍज अ कॉपीराइट अटर्नी, तर मी तुम्हाला एकच सजेशन देईल, यू शुड स्टार्ट युअर करिअर विथ द ऍप्लिकेशन प्रोसेस. ग्राउंड वर्क पासून चालू करा. त्याचे एजंटचे एक्झाम्स असतात ते क्लिअर करा आणि फक्त कन्सल्टेशन करू नका की तुम्ही स्वतः आयपी पॅटंट कसं फाईल केलं जातं, तो प्रोसेस जाणून घ्या. हा, डेफिनेटली आफ्टर 3 इयर्स 4 इयर्स तुमच्याकडे तेवढा अनुभव आला असेल की तुम्ही घर बसल्या बसल्या तिथं कन्सल्ट करू शकता. पण सुरुवातीचे दिवस तुम्ही प्लीज यू शुड गो ऑन युअर ओन. डोंट अपॉइंट एनी अदर पर्सन टू फाईल द रजिस्ट्रेशन. डेफिनेटली यू हॅव टू गो युअर ऑन युअर ओन. तुम्हाला तो प्रोसेस समजलं पाहिजे. जर तुम्हाला आयपी मध्ये करिअर करायचं असेल तर तिथून सुरुवात करा की फायलिंग प्रोसेस कशी असते एखाद्या आयपीची. तिथून सुरुवात केल्यानंतर तुम्हाला सर्व काही सोपं जाईल. आणि देर आर व्हेरियस एक्झाम्स अवेलेबल फॉर द डिफरंट अटर्नी, ते तुम्ही पास आउट करू शकतात आणि तिथून कॅरियर चालू करू शकतात.
थँक्यू सर.
Yes, any other question? Yes, Sandeep Jadhav, Bakshi. Sir, I think there is no question from students.
Okay.
Thank you so much, sir, for your kind and informative session on IPR, copyright, and plagiarism. I hope the students will take a benefit while they are doing research. So thank you so much once again, sir. So I would like to request our student, Miss Saloni Kulkarni, for the vote of thanks.
Good morning, everybody. Before the vote of thanks, I request all the students and participants to please stay in the meeting till the end. There are some instructions for you. I would like to end today's session by thanking Jadhav sir for his insightful and great primer on IPR and copyrights. It was a very detailed explanation that we at law at LLM level or as a law student we require. The introduction to intellectual property, sir, was very enlightening, and the details of copyright and plagiarism were really, really beautifully explained. Your PowerPoint presentation, sir, was actually very beautiful. It was very detailed, and we would like to um, receive a copy of your PPT for our studies and as our material. Uh, I'd like to thank you for taking your time and guiding us all through intellectual property, copyrights, and plagiarism. Um, I'd like to thank our coordinator, Avinash Sarunke sir, for organizing this event. And I'd like to thank all the participants to have taken a part and in in this insightful journey into IPR. So thank you, sir, for today's session, and we would definitely love to hear more from you in some other sessions, hopefully soon. Thank you.
Saloni, for
Uh,
the
yes, the instructions for the students. Um, the participants for today's session who have enrolled and registered, a feedback form will be sent for you in the WhatsApp group created for this webinar. Once you have filled the feedback form, you will receive your certificates on your email addresses. Thank you.
If any of you had taken any photograph, please share with me also. Thank you so much.
Thank you so much, sir. Thank you so much.
Thank you so much,